I'm sorry if I'm interrupting anything. I'm unable to hear the meeting.
Yes, now, Mr. Longstreet.
I can hear you now. Thank you so much.
So as I was saying, I'm sure that Ms. Lewis, who's acting as a secretary, and Mr. Longstreet, our counsel, may want to add something to it. But as I recall, and as I've looked at Mr. Longstreet's report that he has circulated from the meeting, there was a feeling, and I think that this has been a feeling of this board for a while, that we really don't have investigative powers and investigative resources available. So that's one of the primary areas that we're going to be talking about. When we get complaints in, sometimes there's just minimal review that's necessary because we feel that that our group really doesn't even have authority to investigate the issues at hand that are set forth in the complaint. And then there's other times when they come in and they're sort of serious and we're kind of locked up because we don't have a budget, we don't have resources to investigate allegations. So that's one of the areas we're talking about. The second area I think is more general. We agreed to look over the ethics ordinance as it exists, the ethics ordinance with the proposed changes that Dr. Carnell and I believe others took part in putting together. And we wanted to talk about whether we agree with those changes, whether we want to make a motion to adopt those changes, and whether we want to even suggest other changes. So that was the second area that we discussed. The third area that I brought up was the whole concept of conflict of interest, but not as to Wayne County employees, as to our board members. And this has been kind of in vogue because people have been talking about the fact that the United States Supreme Court doesn't have guidelines that apply when somebody wants to make a motion to disqualify a Supreme Court justice. What happens? Well, we all found out that there are no guidelines, there are no regulations. Nobody gets to decide if a Supreme Court justice should be disqualified. We talked about it, and I know that Mr. Longstreet, when he came on board, went back and looked at all the tapes of all the meetings for a couple years, and I don't think that the issue ever arose very seriously, but I will tell you it could arise in the future. So we talked about the necessity of having such a rule. Who would it go to if somebody made a motion to disqualify a member of the ethics board? If somebody made a motion and they believed that it had merit, what would happen if the member of our group decided to deny the motion to disqualify? Who would review it? We know that in a trial court in Michigan, it goes to the chief judge. Well, we don't have a chief judge, so there'd be a likelihood that it would go to chair. Mr. Pinkins might hear that, or maybe it would go to the commission. So we're not sold on the idea yet. It's something that I raised. It's something that we're going to be talking about. And as I indicated, our next meeting is June the 2nd, and we'll be discussing those topics in a little more detail. So unless Ms. Lewis wants to add anything, or Mr. Longstreet, I think that's my recollection of it.
Yes, you pretty much recollected everything. I'll just emphasize that we did talk about making the ordinance a little more user-friendly for the language, people to be able to read and understand the process, and to the reader, and so to the application process. That's all I'll add. I'll defer to Mr. Longstreet if you have additional comments.
Thank you, Ms. Lewis. I don't have any additional comments to make. I have tried to be as complete as possible in the report and our discussions. And at this point, I would leave it up to the rest of the remaining members of the board to add any suggestions they may have to our discussion, or any issues they may want us to raise in our next June 2nd meeting.
Okay, thank you, Mr. Longstreet. Any more you want to add? Well, I take it, Mr. Thomas, that you are considering the type of language.
Yes. Yes, as a matter of fact, on the conflict of interest discussion, I did circulate some language to the members and to Mr. Longstreet, but we're nowhere near making a recommendation on it. It was just something that I had prepared before our subcommittee meeting, and I had it typed up and on my email, and I sent it to the subcommittee members and Mr. Longstreet. So nothing finalized yet, but we're starting. We're getting started. Well, I would have to say that I don't. I would say that if we were told that there was some exigency, we could move up our work. But as I understood things, and I kind of depend on Mr. Slezak for this matter, the whole concept of us making recommendations concerning the ethics ordinance and changes thereto, that's been going on for a long time. I think it goes back maybe a couple years. So if we were told that there was some exigency, we would move up our time frame. But I will tell you, as of right now, and I'll stand corrected by the other members, I don't think that we have talked about self-imposing a deadline for right now. I mean, I would hope to get it by mid to late summer, but I think we could do that. But I would prefer not to have a deadline, because these meetings that we've had, I think our first meeting was about 45 minutes or an hour, which is kind of what our meetings here have been. So I would ask the group here today, do we feel that there's some exigency? Or maybe we could ask Mr. Slezak if he thought that the Wayne County Commission was going to act on this in the near future. We may have to speed up our work, but I think we need at least a few months till we could get back to you with real recommendations.
I would agree with both of what you just said. I think you need the requisite time.
I'm sorry, Chair Parkins, you're fading out. I can't hear you.
Can anyone hear me? Can everyone hear me? I see Ms.
Yes.
Johnson is here. Ms. Johnson, can you just answer a few questions for us with respect to the commission for these amendments? Because as Mr. Thomas mentioned, we did make these original amendments back, I believe it was 2018 or 2019, somewhere around that. I believe it was 2018. I would assume it would go to a subcommittee first, and then before it's presented to the full commission. What subcommittee would this go to? Be considered by?
Through the chair, Felicia Johnson, attorney for the Wayne County Commission. I'm not exactly certain how the commission will handle such revisions from this body. We've never had a situation where comprehensive revisions to an ordinance and potentially changing the policy was recommended to the body. I will tell you that the last ordinance was sent to my office for review. Due to some staffing and other changes, I think I've mentioned here before, we didn't get a chance to thoroughly review it. Obviously, we're not reviewing it now, as you all are continuing your review and potential recommendations. So all I can say at this point is that it will come to my office for review. There will be some discussion with the chairwoman with regards to how to proceed and move forward with those revisions. But I can't speak to what committee or how that process will work at this moment, because I haven't had that conversation with the chair of the commission.
And any sort of updates to any statute? Any laws, any changes to any laws, how would that process work?
So there are changes, and there have been changes. Most changes to ordinances come through my office. They're drafted by my office. There are times where the county administration will make a change, let's say to the fee ordinance, because the department knows that they need updates. And those changes will go through our internal county process. Just like contracts are submitted, the administration submits those ordinance revisions to the commission. Those ordinance revisions are reviewed by my office and other staff members, and then they eventually make it to a committee. In that instance, due to the nature of what that ordinance is, I could tell you what that committee would be, because we have rules with regards to how that process works.
So normally it would go through your office, and then it would at some point make it to a committee, a subcommittee.
Right. All items submitted to the commission are reviewed by staff. In the case of a law, it would be specifically my office.
wouldn't potentially know what subcommittee this would go to until you actually get those here and then decide from that point. So
Right, because depending on the nature of what you all are recommending, whether that's appropriate for a subcommittee, a committee, whether that's appropriate for Kyle, where all commissioners would be involved, whether it's determined that conversation with this body is necessary before revisions are moved forward, depending on what it is and what the commission may want to do. We may want to work some things out before we actually make it to a public meeting. Again, not seeing those recommendations and not having that conversation with the chairwoman, I can't exactly say how that process will work, but there are a few avenues for resolving and reviewing the recommendations.
anyone have any questions for Ms. Johnson at this time?
If I could, Chair, I would like to know, Ms. Johnson, knowing now that your office has had proposed changes that this group made some time ago, a couple years ago, no action has been taken on it. Do you feel that there's any need for us now? We're taking a look at it anew. We may not have any additional changes other than what's been submitted, but we may have some additional changes. The chair asked our subcommittee what our time frame was. Do you see this as a matter where there's some urgency where the commission is going to consider the changes that were submitted in 219? Or do you think we have a few months, or could we request a few months? So that the matter is not viewed piecemeal, so that you don't pick, so that the commission doesn't pick these changes that have already been recommended up and act on them or consider them or discuss them, what have you. Essentially, can we have a few months?
Through the chair, it is within the discretion of this body to determine when you actually submit your recommendation. The commission is not putting or will place a time frame on that. The 2019 revisions are not currently being reviewed because we know that you're currently re-looking at the ordinance. If there was a situation where the commission decided that there was a change necessary for the ethics ordinance, I would let you know. That way we can move everything at one time. There is no such request on the commission side at this point, so you have as much time as you would like. Again, it's within your discretion as to when you submit recommendations, if you do it at all.
Very good. Thank you very much.
I do have one question. Upon our submission of the possible amendments and or changes to the ethics ordinance, I know that the original change.
Excuse me, hold on.
I'm sorry.
Mr. Longstreet, hold on for 1 second. Can you speak up just a little bit louder just so we can hear it for the record?
Sure, no problem. I understand that upon our submission of the changes and our amendments to the ethics ordinance, the previous body sent their changes back in 2019, and up until 2022, there had been no action. Could you give us a time frame of how long it would take upon our submission of those changes for the commission to review and get back to our ethics board in regards to our changes and our amendments?
Somewhat some of the basis of what I was trying to get to, not so much that there's a time frame. My concern is that once this body does come up with these amendments and changes and recommend them to the commission, how long would the process take for the commission to review and if decide whether or not it's going to consider these changes or not, if they're going to even consider them? My concern was that when we did this back in 2019, they were submitted, and up until last year, when we began to talk about, or this year, when we began to talk about making some additional changes, there's been no word whatsoever on the original amendments that we submitted. This is about a 3-year process. Now, we understand COVID came around and things were sort of backtracked. But prior to COVID, I think it was about a good year, we just hadn't heard anything. I know, Ms. Johnson, you had given us periodic updates that you requested, but there was no movement whatsoever. So I think what he's asking and what the chair is asking is, do we have some sort of, once we do have a final set of amendments and we present them, do we have some sort of time frame that we would have some sort of indication from the commission if they're gonna at least look at it or not?
Through the chair, any revisions submitted by this body will be reviewed, at least by staff. I can't speak to the process beyond that. So there will be a level of consideration. With regards to timing, it's hard to say. It really just depends on what's happening within the county. So let me give you an example. Everyone is aware that the county is in the process of building a new criminal justice complex. Well, that complex is due to be open soon. The county will be looking to move in. There will be probably hundreds of items that would need to be taken care of in order to make that process, and that process is timely. So in that instance, that will probably be a priority over these ordinance revisions because there's no real time frame for that. So it really just depends on what's happening within the county. So it's very hard for me to give you a time estimate because it literally depends on what is going on at the time they're submitted and other deadlines and individuals within the county setting priorities to make sure the county business moves forward appropriately. So unfortunately, I cannot give you a time frame, but I will say that those revisions will be reviewed. We anticipate that they will be reviewed in a more timely fashion than the original submissions. Other than that, I can't give you a date.
Thank you, Ms. Johnson. Mr. Longstreet, did that answer your question, or do you have further questions?
It does. It's just an indefinite time frame, and I understand.
Thank you, Ms. Johnson. All right, is there any more questions regarding the changes to the ethics board or the subcommittee amendments at this time? Any further discussion from the subcommittee on this matter? If not, which is item D, which is new business. Item number 1, we have a complaint from Mr. Dwayne Williams regarding a medical examiner's office employee. I believe everyone might have received a copy of the complaint from Mr. Williams. Has everyone had the opportunity to review the complaint? Or to Mr. Longstreet. Mr. Longstreet, have you had an opportunity to look at the complaint from Mr. Williams, and do you have any recommendations at this time, sir?
I do. I have had an opportunity to look at the complaint or the attempted complaint by Mr. Dwayne Williams, who is a Michigan Department of Corrections inmate. His complaint or attempted complaint makes allegations of malfeasance against the Wayne County Medical Examiner's Office. However, his complaint does not fit within the jurisdiction of Wayne County Ethics Board. His complaint was improper. It failed to spell out any violation of the ethics ordinance, and at this time, it would be my recommendation and opinion that this board should dismiss this complaint without any further action.
Williams?
I'm sorry, Chair Pickens, I couldn't hear you, sir.
Is there any, I'm just asking the board, is there any further questions from the board regarding this complaint from Mr. Williams and also Mr. Longstreet's recommendation?
Question, do we have any,
Louis?
even though it's out of our jurisdiction, Mr. Longstreet, do we have any responsibility? I know he alluded to, I think he sent it to the medical examiner.
I'm sorry, Mr. Lewis, I can't hear you.
He alluded to that he sent it over to the Wayne County Medical Examiner in his complaint. Do we have any responsibility to forward it over to them, or?
Not at this time, I don't believe so.
Okay.
Because the complaint is improper, the only time that they would have a response if he actually did submit a proper complaint, spelling out an alleged violation of the ethics ordinance. If there wasn't an alleged violation of ethics ordinance, then I would have to ask that the medical examiner's office, and at that point, file a response to the complaint. Because the complaint was not proper, there would be no reason for the medical examiner's office to respond.
Okay, thank you.
Yes, since this did not come in like proper form, because we don't have any like notation on what part of the ordinance was violated, do we even dismiss it or act on it? Or should we just put for the record like a note that we're not going to act on it because it's not in the proper form?
At this point, it would just be my recommendation that we take no action. At this point, because there isn't anything to dismiss, because there isn't a proper complaint, I would just recommend to the board that we just take no action on this matter.
Well, the recommendation, Mr. Longstreet, is to take no action, or is it to dismiss the complaint?
To take no action. There is actually nothing to dismiss because the complaint is improper.
Taking no action, then what would that entitle some sort of?
I'm sorry?
That means some sort of communication with Mr. Williams to indicate to him that his complaint is not in the form of a complaint that will come before this ethics board? Is it sort of indicate to him that fiction or what would happen if we take no action? That's what the chair.
Well, at this point, what I would do is I would just simply send a response letter back to Mr. Williams saying that his complaint is insufficient in regards to his allegations of the ethics ordinance. He failed to spell out the section of the ethics ordinance that was violated. And I would also send him information that he needs to properly file a complaint to the ethics board in order for his issues to be heard.
Mr. Longstreet, one quick second. I apologize. I'm gonna have to ask you to sort of repeat what you said. Some of the members here can't hear what you're saying. So I'm not sure if you can turn up your volume a little bit more, but I just want to make sure everyone hears what you're saying too for the record. I apologize for those who haven't heard or been able to hear. I know some of the audio is not clear, but yeah, if you can speak up a little bit louder.
Very well. The only thing I would do at this point is I would send a response letter to Mr. Williams indicating that his complaint is insufficient, that he needs to properly spell out what portion of the ethics ordinance was violated, and then resubmit his complaint for consideration.
One thing I did note, and from the chair, I did note that the complaint wasn't notarized. Also, will we let him know that in the facility there, it's my understanding that I believe we sort of, and correct me if I'm wrong, Mr. Longstreet, do we waive the notary requirement when they're in the facility, or is they get it notarized for free or something like that? Is that how it works when they're in?
I haven't seen anything in the ethics ordinance or part of the complaint process that provides a waiver for the notary requirement. I would imagine, and I don't know the answer to this question, but I would presume that there would be someone at within MDOC that can provide a notary. But I don't see anything in the ethics ordinance that would allow us to waive the notary requirement. Not that I've seen.
And when they're incarcerated like that, when a person is incarcerated, do they have proper access to the website to actually know how to file a complaint? I mean, I assume they have internet inside the facility, so.
I would presume that would be a question more appropriate for the MDOC, Michigan Department of Corrections. I'm unaware of whether they have the facility and or the equipment available to the inmate for them to use internet. I know through my criminal practice that oftentimes I receive lots of emails through core links from inmates. So I know there is some type of internet process there. What the availability is of that, I'm unaware. That's a better question suited to the Michigan Department of Corrections and or the specific facility. The answers to that question can also be determined upon where they're actually been housed. Some of the Michigan Department of Corrections facilities are better equipped than others, so it would be hard to say.
Okay, thank you, Mr. Longstreet. Is there any further questions from Mr. Longstreet at this time?
Chairman?
Yes, Mr. Young.
Yeah, just trying to determine if I can what the recommendation was. So if we take no action, are we suggesting that we direct Mr. Lund to send a letter asking for additional information? Are we removing it from the agenda? Are we allowing time to correct the deficiency in the complaint? I mean, what is it exactly that we should be doing?
Well, at this point, to answer your question, Mr. Young, the board is to take no action. It's up to me at this point to respond to Mr. Williams, telling him what the deficiencies are and the proper way in which he should send his complaint. And then when I do receive a proper complaint from them, once I receive a proper complaint from him, then he can send us then I can give a response, or we can give a response to what his complaints are. But at this point, my recommendation is that the board take no action whatsoever.
Yes, Mr. Young.
So does that mean that this will come back at the next board meeting, or do we have to do something to get it off the agenda? Will it just be removed automatically and wait to find out if there is a response from the complaint, or how does that work?
Well, at this point, the ethics ordinance requires that once I've told you what my opinion and recommendation is. And then I've given the board directives on what I believe should happen. If I'm recommending that there is no action be taken, then if the board takes no action, and then I then respond to Mr. Williams and tell him what his defenses are. Once the complaint is properly filed, then I will resubmit my opinion to the board if the board should take action on his complaint or not. But at this point, my recommendation to the board is to take no action to Mr. Williams as it's not properly filed.
So by taking no action, then this would just be removed. And then if Mr. Longstreet receives information and he would bring it back and it would reappear on the agenda. Is that what I understand then, Mr. Chairman?
That is correct. That is correct.
Yes, Mr. Thomas.
If I may, the problem that I have no problem with the concept of writing to him and telling him that the complaint was deficient. But the concern that I have is that if we do that, by implication, it may imply that we have authority or we have jurisdiction over this within the ordinance. And I see this as a criminal complaint, or a complaint concerning a criminal case that took place sometime around 2012, 2013. And he's complaining that at some juncture, the medical examiner changed their findings. I would have no problem in a letter to him stating this complaint is deficient. You didn't have it notarized and these are the different problems, but we also want you to know that looking at facially the information that you provided, it doesn't fall within the ordinance. I don't think that we could do anything. A trial judge apparently has allowed that change to the medical examiner's report. There would have been evidentiary hearings. So my concern would be that if we just send him a letter and say, look, sir, what we want you to do is bring this complaint in conformity with our requirements. You could go on a computer, look up on the website to see what our requirements are. It's almost going to be misleading. I just think that he should be told that facially it doesn't look like we have authority here. So but I will tell you right now, I would not oppose a motion if there was a motion to send a letter out such as Mr. Longstreet is suggesting. But I just think something should be added in there about the jurisdictional problem. I don't want to mislead the man. I really don't. Because in his complaint, he makes it clear that he's looking for help. If his complaint, if there's a problem with it, he's almost asking, is there somewhere else that you know that I could go complain? This is a matter that would be ripe for a motion for a new trial. Even though 10 years has gone by, they could always file a motion for a new trial. So that would be my concern, Mr. Longstreet. But other than that, other than my suggestion that maybe some added language be put in there to let him know that on its face, it doesn't seem that we have authority, I will go along with whatever is suggested.
Well, to answer your inquiry specifically, to me, the complaint was a little vague in regards to what the matter was associated with. Yes, I can presume that was a criminal matter, but I think the main point was that they were making allegations of malfeasance against the Wayne County medical examiners. And I think medical examiner's office, and if properly cited, I imagine that it could fall within the ethics ordinance. I don't know if it was specifically a criminal complaint, because I believe that the complaint again was vague, but I have no problem adding additional information that even if you do file a complaint properly, it may not fall within the guise of the ethics ordinance.
I would be satisfied with that. For me, I would be satisfied with that. I don't know how the other members feel, but I think that little added caveat in there, or little notice to them would be helpful.
That's not a problem.
That you would have with Mr. Williams?
Pardon, I'm sorry?
You would have that, you would add the additional language into the communication that you would have with Mr. Williams regarding the jurisdictional issues?
Yes.
Okay.
Yes.
Okay. Mr. Thomas, does that satisfy your question there, sir?
It does. And if a motion is needed to send such a letter, I will make the motion to send the letter as Mr. Longstreet has said he would put it together.
Not sure if we need a motion at this time. We'll just need to adopt Mr. Longstreet's recommendation. At this time, any other members have any questions regarding the recommendation? The recommendation, as I understand it, is to take no action, and Mr. Longstreet will sort of follow up with Mr. Williams regarding the insufficiency of the complaint and as well as jurisdictional issues regarding the complaint. Does have any other questions or concern regarding that recommendation?
Chairman, I guess what we would do
Yeah.
then is we would make a motion and take action to take no action and just have it removed until we receive, if any, a response. If that's appropriate, I would make that motion.
Allow. So what we have right now, we have a motion we have a recommendation from Mr. Longstreet. We have a motion from Mr. Young, which is a motion to, I believe, take no action with respect to the motion, the recommendation from Mr. Longstreet, which is to take no action. At this point, we can just sort of combine both into one motion, and the motion will be to adopt the recommendation of Mr. Longstreet, which is also the motion of Mr. Young, excuse me, to take no action regarding the complaint. Will be removed from the agenda as Mr. Longstreet will follow with Mr. Williams concerning the issues of his complaint. Favor, excuse me, is there a second to the motion? Second, so thank you for that, Mr. Thomas. All in favor indicate by saying aye.
Aye.
All opposed indicate by saying nay. The ayes have it, so moved. All right, moving on to the next item of our agenda. It's item number 2. We have a complaint from a Giovanna Foster regarding 2 nonprofit organizations. I believe all members have received a copy of the complaint from Ms. Foster. I assume all members have had the opportunity to read the complaint. At this time, I'm going to refer to Mr. Longstreet. Mr. Longstreet, I'm assuming that you had an opportunity to review this complaint. What are your suggestions at this time, sir?
Thank you, Chair. I have had an opportunity to read the complaint from Ms. Foster. Again, it is improperly filed. She did use the proper documents. However, she failed to specify a specific portion of the ethics ordinance that was violated. Secondly, these are 2 nonprofit community-based organizations, the Wayne Metro Community Action Agency and ChristNet Services or ChristNet Christian Services. Neither one of these organizations fall within the purview of the Wayne County Ethics Ordinance. There would be nothing that we could do to enforce the ethics ordinance against 2 nonprofit community organizations that have nothing to do with the county and do not fall within the jurisdiction of the ethics ordinance. And I would simply make a recommendation, an opinion at this point, is that the board take, again, no action on this matter, that Ms. Foster be advised that her complaint does not fall within the guise of the ethics ordinance, and this matter be dismissed without any action.
Recommendation, is there any questions at any time at this time right now from any members? So at this time, there's a recommendation to take no action. Is there a second or is there a motion to adopt Mr. Longstreet's recommendation? Yes, Mr. Thomas, thank you, sir. Is there a second? Yes, Mr. Lewis, the motion has been made. The motion has been seconded. All in favor?
Aye.
Aye.
All opposed? The ayes have it, so moved. Moving on to the next item of our agenda is item E, which is such other matters that may be properly submitted before this board. This time, are there any other matters that's properly submitted before this board? That this board needs to discuss at this time. The chair would just bring up one issue. How is it with respect to the subcommittees? Everything going okay there with the meetings, with the Zoom conferences? Everything is being, the needs are being met?
I'll defer to the other members if they'd like, but I will tell you from our perspective, the staff did a great job setting up the Zoom call and we all participated. We didn't have any problems, so we're satisfied.
Cora, Mr. Slizak, thank you so much for facilitating these things. All right, if there's no other matters, we're gonna move on to item F, which is public comments. Is there any public comments? I don't think we have any. All right, there's none. I believe the next meeting is June, if I'm not mistaken, I believe it's June 15th.
Through the
Chair
chair,
Pinkins?
this is Joe Slazak. It's June 8th is the next full board meeting at 9 a.m. here in the chambers. Because June 15th, we do have committee meetings that we have to administer.
Chair Pinkins, for the record, we have not received any emails or comments.
Thank you for that. Thank you for that. All right, so if there's no public comments, I'm going to entertain. I did just look at my calendar and I did note that for some reason, I've been summoned for jury duty, so that should be short. I'm sure they won't take me, but, but I've been summoned, so. So if I'm not here, sir, Mr. Thomas, hopefully you can take over the chairmanship, sir, in my absence. If no further questions, there's no public comments, I'm gonna entertain a motion to adjourn at this time.
Motion to adjourn?
Okay, we have a motion to adjourn on the floor. Is it a second?
I second.
Thank you for that, Ms. Lewis. The motion to adjourn has been moved, it has been seconded. We stand in adjournment until June 8th at 9 a.m. Thank you so much, everyone, for being here.